Our presenter today is Professor Lisa Dolak. Professor Dolak is the Board of Advisors Professor of Law here at the College of Law, and most recently was the Senior Associate Dean for Academic Affairs. Professor Dolak served as a law clerk with the United States Court of Appeals for the Federal Circuit in Washington, D.C., which is widely regarded as the Supreme Court for patent matters. She also worked with Nixon, Hargrave, Devins, and Doyle in Rochester as an associate in the Technology and Intellectual Property Practice Group. Professor Dolak is the author of numerous articles, and she is admitted to the state of New York, the United States District Courts for the Western, Eastern, Northern, and Southern Districts of New York, the United States Court of Appeals for the Federal Circuit, and the United States Patent and Trademark Office. Welcome, Professor Dolak.
Thank you very much. I'm pleased to have this opportunity to talk about a subject that I have worked on for many years. This, like many of my research projects, was born of clients' interest. This, back in the early 90s, as I was an associate at Nixon and Hargrave, we began to get inquiries from our clients who were transitioning the keeping of their research records over to the electronic form, and they asked for guidance about the legal sufficiency of those records, as well as the legal admissibility of those records. So that was the birth of my interest in this subject, and I've remained interested in it over the years. So I'm going to talk about establishing first to invent and electronic lab notebooks. And since I was asked really to focus on first to invent, date of invention, I'm primarily going to set our context as situations where we are proving priority of invention, more about that in a moment, and validity challenges. So taking those one at a time, priority of invention, that concept stems from the fact that in the United States, as well as in most other countries, there is only one patent granted per invention. So there has to be a way to determine when, as is not unusual, two or more inventors or groups of researchers are working on a problem and the solution to a given problem at about the same time, and they come up with the same solution at around the same time, which of those groups of inventors or researchers is going to be entitled to the patent. In the United States, we, under current law, and for a long time, have determined who is first to invent. In other words, the first to invent is entitled to that one patent per invention. The entire rest of the world operates on a first-to-file system, and there has been pending in Congress for the last several years, since the spring of 2005, and there continues to pend in Congress at this moment, legislation that would change the United States from a first-to-invent country to a first-to-file country. None of us is able to predict with certainty what will happen with respect to that legislation this year or in the future. I think it's inevitable that we will ultimately move to a first-to-file system, but for the time being, we are a first-to-invent system. And of course, even if we convert over to a first-to-file system and award the patent on competing patent applications to the first inventor or group to file their patent application, obviously that change in the law will operate prospectively and not retroactively, and so for a long period of time, even after we go to a first-to-file system, evidence of first-to-invent will remain relevant. We determine priority of invention in what are called interference proceedings, and they take place primarily inside the United States Patent and Trademark Office before the Board of Patent Appeals and Interferences. And this is what we call an inter-parties litigation, but it is quite a bit different from what we think of as federal district court litigation in many ways. The primary distinction being that the testimony is submitted in writing, although there can be deposition testimony, but the testimony is submitted to the tribunal in writing, and so that's a significant distinction. But the issue is which of the two or more, sometimes it's more inventors or groups of contestants, was the first to make the invention, and we'll talk about what making the invention constitutes in a moment. It is possible to have interference proceedings that take place in the district courts. There is a provision of the statute, Section 291 of the Patent Act, authorizes the determination of priority of invention between two patent holders in the district courts. Those are exceedingly rare situations, however. In most cases, the conflict between two patent applicant contestants for a given patent reveals itself while at least one of the applications is filing and the litigation takes place inside the U.S. Patent and Trademark Office. Validity challenge is the second principal context in which we would be concerned about proving a date of invention. Most patent litigation takes place in federal court. The vast majority of patent issues are determined by the federal court. And but the context gets subdivided here. It can either be the situation where a patent challenger, an accused patent infringer, is attempting to rely on proof of its or a third party's invention-making activity in order to invalidate the rights of the patent holder. Alternatively, it can be the patent owner who is trying to prove a date of invention before the district court when they are seeking to antedate or get behind a piece of prior art, asserted prior art, that the accused infringer has proffered. And so they're trying to say that something that has been proffered as prior art is in fact not prior art in the statute because the patent owner can antedate it with evidence of invention. So that's really the context in terms of where we are concerned about proving dates of invention. I would like to say, since I don't come back to this later, that even under a first-to-file system, and even aside from the importance of proving invention dates retroactively with respect to patents that were procured or applied for prior to the effective date of the legislation, and of course we have no idea what kind of effective date provisions will be set, but even aside from this issue of retroactivity, it's not the case that invention notebooks and laboratory notebooks will become completely irrelevant. They have utility aside from proving invention dates, and those utilities don't necessarily tie themselves to the patent law. They might relate to other regulatory bodies. They might relate to assisting an organization prepare materials for venture capital companies or other kinds of reports that the organization has to make. So it's hard for me to imagine that lab notebooks will go away in any event. But inside the patent context, it seems likely that they will continue to have a very important purpose aside from invention date, and that relates to who is or are the proper inventors of a given patented subject matter. And so certainly, even with respect to assisting the patent attorney in determining who the correct inventors are, that's a legal determination. That's a determination that the inventors and the business people really don't get to make with respect to who are the inventors. And it may be a situation where in order to competently make that determination, the patent attorney has to evaluate the laboratory notebooks. And certainly if there is a dispute, even within an organization or between organizations who are doing a collaborative project with respect to who are the proper inventors, those laboratory notebooks can provide valuable evidence. So, turning back now to inventive activity and the definition of what constitutes making an invention, it's more complicated than simply saying making an invention. Making an invention in the United States has several components. One aspect is the mental part of inventing, the so-called conception of the invention. The legal definition of conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is thereafter to be applied in practice. But the easy way of thinking about it, of course, is the mental part, when the idea occurs to the inventor. One thing to note there, of course, is that conception, while it occurs in the mind, as a legal matter, what is proved as your conception date is the date that that conception is somehow manifested to third parties, either in writing or orally. In other words, the law is never going to take an inventor's word for the notion that he or she came up with this idea in the shower on a certain date. That's the conception part of it. Reduction to practice involves proof of physical events. We're talking about the concept known as actual reduction to practice. There is a related concept known as constructive reduction to practice, which is evidenced by filing a patent application. But for various reasons, that's not particularly relevant to what we need to focus on today. Actual reduction to practice is defined in the law as the constructing of the invention and demonstrating that it is useful for its intended purpose. And that typically involves testing the invention, because for most inventions it is not readily apparent necessarily at the moment they are constructed that they will work for their intended purpose. But the technical definition involves certainly constructing the invention and somehow demonstrating that it is useful for its intended purpose, including, interestingly enough, actually appreciating the success of the invention. There is a legal requirement that a human being, under current law, a human being must become aware that the experiment worked. The third concept that is relevant to proving invention dates with lab notebooks, electronic or otherwise, is diligence. Diligence is not always at issue, and it's really beyond the scope of this presentation to get into the situations when it is at issue. But when it is at issue, it involves an inquiry into whether the inventors worked diligently, relatively continuously. It's a fairly unforgiving legal standard from either their conception or at least from the time just before the other party at issue began their work in the field, up until that inventor's own actual or constructive reduction to practice. So diligence is not something that is proved typically as a matter of a single event. It's proved over a period of time, and you can see as you think about that how important laboratory notebooks might come into play if the objective is to prove that a given person or persons was working relatively continuously on a project. You would need evidence of returning continuously to the project to advance it. So those are the concepts as far as making an invention. The basic rule of priority of invention, again, a little bit oversimplified, but for our purposes sufficient. In this country, the first to reduce to practice wins unless the other party was the first to conceive and worked diligently toward his or her own or their own reduction to practice. So that's the definition. So the point is, in a priority contest, where the issue is priority of invention, as we talked about earlier, these are the events that the parties are seeking to prove, depending on the state of their proof and all of the circumstances. They might be trying to prove that they were the first to reduce to practice. They might be trying to prove that they weren't necessarily the first to reduce to practice, but that they were the first to conceive and have this evidence of diligence that they're going to need. In real life interferences, of course, you can have alternative theories of why you win. Your theory may be we were the first to reduce to practice, but if we can't show that, at least we can show we were the first to conceive and were diligent. So the point is that at the time the attorneys are actually concerned about proving dates of invention, they might be coming up with alternative theories under which they can prevail. And so the point there is that when the invention records themselves are being created, it's not possible for the inventors to know, or for the business people to know, or for anyone to know with any certainty that any given piece of evidence will have significance, or how much significance it will have. Dates of invention are proved looking backward, looking after the fact. And so the attorney, what the attorney wants to see when he or she comes in and is assigned the task of proving an invention date, is credible, reliable evidence, useful evidence that the attorney can construct the case and the theory of priority from. So what do we need? We need admissible evidence, we need credible evidence, and I'll talk more about those going forward. One note I make here and nowhere else is that, and this is part of the concept of credibility, the credible evidence will be evidence that was created as of the time of the events, that is contemporaneous with the events that are being relied upon for proof of conception, reduction of practice, or diligence, and have been maintained in a fashion that will lend or maintain their credibility, those records, going forward. Corroboration is not something we've talked about yet. Corroboration is a requirement that is unique to proving invention dates. And I'm going to spend some time talking about that. But just looking at this slide, it is clear that it's not simply a matter of having admissible evidence, and it is not simply a matter of having credible admissible evidence. It's also a matter, when you're talking about proving a date of invention, that there be corroborated, admissible, credible evidence. So it's a significant evidentiary hurdle, and this is why electronic lab notebooks are, there is such a focus placed on laboratory notebooks, electronic or paper. A few more words about corroboration. The rule of corroboration is this: evidence that emanates solely from the inventor or inventors must be corroborated by evidence that is independent of the inventors. And we'll get the opportunity to consider some examples in a moment, but that's the requirement for corroboration. It applies to testimony, documentary, and physical evidence. In other words, if the inventor's testimony, which in the Patent Office, at the Board of Patent Office Appeals and Interferences, will be submitted in declaration form, no matter how honest and how much integrity the inventor has and how credible his story is or her story is, as a legal matter, as a matter of law, the date of invention cannot be established purely on the testimony of the inventor. And that goes for the inventor's notebooks, and it goes for the inventor's inventor-generated testing data. There has to be corroboration that emanates from someone other than the inventors. And so it's a significant hurdle, and this, I feel, has to be an important consideration when you're designing a laboratory notebook system, whether it's paper or electronic, this requirement for corroboration. This requirement has been with us for a long time. The first evidence of the requirement actually comes from a case in 1869 where basically the inventor with corroborated evidence prevailed over the inventor with uncorroborated evidence. So it began really as a rule of preference, but it evolved in the late 1800s into a strict requirement, this notion of, as a matter of law, and sometimes it's referred to as this way: as a matter of law, inventors are presumed to lie, and there has to be independent corroboration. In fact, when I was associate in my law firm, one of the senior patent attorneys used to say that the only two people in the law who are presumed to lie are inventors and traders. I'm not even sure traders are presumed to lie, but inventors under the patent system are. And not only did it become a requirement as a matter of law, but it was very strictly applied. There was essentially a requirement that there be over-the-shoulder corroboration, that a witness could testify that he or she stood in the presence of the inventor and watched the experiment work. So it was a strictly applied requirement until about the mid-1960s. The rationale for the requirement is the one I've alluded to several times. The Supreme Court says, for otherwise, given what's at stake, valuable patent rights, there would be a great temptation to perjury. Today, since about the mid-1960s and continuing today, the rule operates on a less strict basis. It operates under what we call the rule of reason, and again, I've got some examples to illustrate how that works. So how do we go about satisfying these significant evidentiary hurdles? Well, traditionally, the classic evidentiary tool has been the paper lab notebook. And so I think in terms of thinking about what an electronic laboratory notebook system should have, it is valuable to think about the analog version, the paper version. What were the traditional attributes of paper lab notebooks? They were permanent. They were kept in ways to imbue them with permanence. Writing in ink, bound, no sheets of loose leaf, and with other steps that I'll talk about in a moment. They were complete. Researchers are taught how to keep records of inventive activity, conception, etc., and they were continuous. They were maintained on an ongoing basis, and again, just one reason why you would want to do that is should it become necessary to prove diligence. Another reason, as I mentioned, is that it is not possible at the time the records are being created to appreciate the relative significance of them. It's a backward-looking determination. So, what were we taught? And I worked for several years as a synthetic organic chemist in the pharmaceutical industry, and so I had the experience firsthand of being taught how to keep a laboratory notebook. We were taught to record not our ideas. We had separate conception notebooks. Certainly that's not necessary, but it's customary in my experience in the pharmaceutical industry to have a notebook that some people carry them with them all the time to write down their ideas. Experimental protocols, results, and any observations. I'll say here as a parenthetical, one of the things that we were taught and that the cases bear out as a good notion in this regard is to take care with respect to characterizing results. Remember that notion I said a while back about appreciating the success of an experiment. It's devastating for an attorney who's trying to put together an invention case to find the evidence that he or she needs on a given page of a laboratory notebook, only to discover that the inventor concluded the entry with some comment that the experiment was a failure. So we want to be careful. What I tell students when I teach this sub-material and inventors when I have a chance to speak with them on it, just the facts go into those laboratory notebooks. No characterizations. Today's failure might be tomorrow's success. The standard recommendations for keeping laboratory notebooks use bound notebooks having consecutively numbered pages so that any alterations can be detected, so that anything that's been inserted after the fact will be apparent. Don't skip pages for the same reason. Record entries in ink, and this is one that was always a challenge for me when I was working in the lab, the notion of no paper scraps. I'm great at grabbing for the notebook and writing things down. We were taught to hold that laboratory notebook right at the bench or the hood and record information directly because there was too much risk that information would not find its way in there if you did it any other way. The standard recommendations continue: no erasing, draw lines through materials, sign and date corrections. Again, the obvious utility here is that the attorney comes back and something that the inventor or someone else in the lab didn't appreciate as particularly significant and therefore erased it, has disappeared. If it's there, even though there's a line through it, it might have evidentiary value. So draw a line through mistakes, sign and date alterations so that we have a paper trail of when changes were made and by whom. No skipping space. And of course they have to be, in order to be useful, years down the road, perhaps 5, 10, 15 years down the road, maybe even longer, in proving an invention date, we have to be able to find the evidence. It's not enough to create the evidence in a credible manner and maintain it. We have to be able to find it. And so the paper notebooks are carefully indexed and stored in a way that will protect them from destruction or damage. The bottom line, laboratory notebook recommendations that I'm sure all the researchers are familiar with: sign, date, and witness. And I'll come back and talk about the legal significance of these aspects. But that's the analog version. And again, I think that it's useful, and I will have some evidence to back me up in a moment, that it is useful to think about the way the attributes of traditional lab record keeping and when thinking about how to design or incorporate an electronic lab notebook system into a research program. Now, what about electronic research records? What advantages can they bring to the table beyond, over and above paper record keeping? Well, some of those, and I'm sure that there are many others that didn't occur to me, but some of those is obviously the same thing that all digital records offer. This convenient data handling, graphics capabilities, the ability to incorporate structures and graphs and create those things as the data is being generated, and to be able, more importantly, to incorporate that information directly with any kinds of textual descriptions of experimental work or conception et cetera. So the way to integrate graphics and text is an advantage that is superior in the electronic notebook or the electronic research records context. The analog and the paper world has been to have a graph or a diagram that's perhaps generated by a different machine, an instrument, or perhaps a drawing on the back of a napkin at lunch or something like that, and come back to the lab and securely affix the graphical information into the lab notebook, and then we were taught to sign across the boundary between the affixed material and the notebook, again, to imbue the notebooks with credibility. Searchability, obviously, there's tremendous advantages offered by, in the electronic research context, for searchability with which paper records cannot compare. There is the ability to easily share data among researchers within an organization or between organizations. And this notion, as I mentioned a moment ago, of directly incorporating instrument-generated data is more easy to achieve in the digital arena than in the paper arena. So there are a number of advantages. Again, I'm sure there are many that didn't even occur to me. But the reason that we're having this conversation today is the concern that my clients came to me with in the early 90s, and that clients continue to come to their lawyers with to this date, is the issue of whether or not these records will suffice to prove date of invention. Will the USPTO board, will the courts accept this kind of electronic evidence of invention? I mean, there are good reasons to be concerned, at least when the inquiry is begun. For one thing, think about the fact that the courts and the board are used to dealing with paper laboratory notebook evidence. And so it's something that they're familiar with, at least in the USPTO. Some of the administrative law judges are themselves technically trained. They themselves may have kept laboratory notebooks. And so it's customary evidence. And we take a lot of comfort, including in our legal system, in things that are customary. The other notion is that there is traditionally a character to paper notebook records that it is hard to replicate in the electronic world. And that is, and you think about it this way, your old lab notebook, if you kept it correctly, you kept it, in the case of, say, an organic chemist, right there at the bench with you, you spilled stuff on it, coffee, chemicals, it smelled bad, it was discolored. How could it not be authentic? It had a character of authenticness about it, and this notion that it gave assurances just by its appearances and character that it had not been altered or tampered with. And obviously the concern with digital records is the ease of alteration. And so that's the basis for the concern. So what's the law? Well, we start from the principle, we start with the law that we have, of course, and the law that we have is pretty comforting. The district courts have over 3 decades of experience with electronically stored and generated evidence. There has been recently revisions to the Federal Rules of Civil Procedure that expressly deal with discoverability of electronically maintained records. And there's been a lot of information circulated, lots of conferences about the significance of that rule change. But it is important to recognize that since 1974, the Federal Rules of Civil Procedure have provided for the use in litigation of so-called data compilations, electronic evidence. And there has been litigation around the admissibility and credibility of that evidence in the district courts since around that same time. The Federal Rules of Evidence provide that evidence is admissible if relevant, relevant being an extremely low threshold. Basically anything that bears on an issue, one way or the other, will be relevant. That is authenticated. We'll talk a little in a moment more about authentication. But what we're getting at there is that the evidence is what it purports to be. If we claim it to be a page from a lab notebook, from John's lab notebook, that's in fact what it is. And there is going to have to be some kind of authentication testimony to establish that before it will be admitted. And then finally, there is the concern about hearsay. The hearsay rule provides that hearsay is inadmissible. There are exceptions to that rule. One of the principal exceptions that's relevant for the admissibility of electronic and paper research records is the so-called business records exception. That records that are generated and maintained in the ordinary course of business, including a research organization, can overcome that prohibition against hearsay. Hearsay, of course, being an out-of-court statement offered to prove the truth. And so you can get records in through the testimony of the records custodian. But you can also get records admitted into evidence through the testimony of the records creator. And that's why I say vouched for by the witness. If the witness is the creator of the record and is on the stand in district court, as they would be, or has submitted a declaration in an interference proceeding, is therefore available himself or herself for cross-examination, that's what we mean by this concept of vouched for by the witness. I'm emphasizing the participation of human beings in the authentication and vouching functions relevant to admissibility for a reason. And I'll come back to that, but I want to call everyone's attention to the fact that, that the key point is that records will not admit themselves and will not necessarily speak for themselves. The human factor is going to remain an important one, whether in the paper lab notebook context or the electronic context. So that's the basic background there. What about these concerns and suspicions about whether records have been tampered with, or whether the data collection apparatus might have been subject to errors, or that this notion that the what's actually coming into court was never printed until the litigation. So the record actually didn't exist in the form it's being proffered at the time until the litigation. We have this suspicion about records that are prepared for litigation. These and other objections have been raised before the district courts, and these aren't patent cases necessarily. This is general federal district court litigation and state court litigation. But the good news is that the courts have generally turned back these kinds of challenges. The notion that the printout offered was prepared for litigation. The record existed as of the time, it was contemporaneous with the event. The mere fact that the printout is being created now in preparation for litigation has been viewed as not a sufficient objection. The notion that we can't prove that the computer or the other device that created the record could never commit an error has not been sufficient. The fact that it is possible to go back in and change stored data has not itself been regarded generally as a sufficient barrier to the admissibility of electronic evidence in the courts. Short of some evidence that the record at issue, in fact, was changed. So the general concept that digital data can be changed has not been sufficient in the courts. Neither has been the notion that there may have been an error during input. Again, the courts have required more as a general matter, some evidence that an error, in fact, occurred. So that's a little bit of background. The courts have, as I said, admitted electronic records over these and other objections, but have made very clear that admissibility is not the end of the game. Your admitted records will do you no good if they are inherently suspect. They have to also be credible, and it is up to the fact finder, and of course in a jury trial that fact finder will be the jury, and there certainly are juries in patent litigation who will get to decide how much weight a given record that has been admitted into evidence is entitled to. So in the district courts, as a general litigation matter, and certainly in patent litigation, we have to worry about admissibility, we have to worry about credibility. What about in the USPTO? the USPTO has rules. The interference proceedings have their own rules. In fact, they are some of the most elaborate rules in all of the law. This is why there are people who are real interference specialists. The USPTO's rules of interference expressly provide that the federal rules of evidence, the same evidentiary rules that apply in federal district court, apply in interference proceedings. And that's so that background that we went through is not just important for federal district court litigation, it's important inside the Patent Office and before the Board of Appeals and Interferences. And in 1998, the USPTO issued a notice which included these two statements. In fact, the way I have it presented here is a little misleading. The notice didn't just include these two statements, the notice consisted entirely of these two statements in back-to-back in a paragraph. I've teased them out separately so we can focus on them separately. But this notice that came out in early 1998, and it was in reaction to the concerns that were being generated about whether or not the increasingly used electronic records could be admissible for proof of priority of invention. The notice says electronic records are admissible as evidence in interferences before the Board of Patent Appeals and Interferences to the same extent that electronic records are admissible under the federal rules of evidence. And so expressly incorporating these notions of admissibility from the district courts into interference proceedings. But notice what the second sentence says, and this was particularly gratifying because it had been the advice that my colleagues and I had been giving our clients since the early 1990s. It is not enough to worry merely about admissibility. The board came out and said, the weight to be given any particular record necessarily must be determined on a case-by-case basis. It is not possible, it's not consistent with our legal regime for the board to give what some of my clients were hoping for, some sort of across-the-board blessing of electronic evidence. It's just like paper evidence, and the weight to be given any particular record will be determined on a case-by-case basis. Okay, so what do we need? We need, as we've said, evidence that is admissible, evidence that is credible, and evidence that is corroborated. And I'd like to spend the last portion of the presentation stepping through each of those in the context of electronic lab notebooks in particular. Admissibility, what do we need? We need that foundation testimony, that human being. We need either the author of the record who will then adopt those words, that out-of-court statement that he or she made perhaps 5, 10, 15 years ago, will come into court or before the board and adopt those statements as if they were being made today, that kind of foundation testimony, or if it's necessary to get around, and thus converting them, by the way, in other words, from no longer being hearsay. They are statements that are now being made in court, and they are subject to cross-examination. If we don't have the author of the record, perhaps the inventor or other witness is unavailable or deceased, the records custodian, the keeper of the records, can come in and talk about the routine procedures that the organization relies upon in the creation and maintenance of its records. The theory, of course, behind the business records exception to the hearsay rule is the courts say if it's good enough for the business, it's good enough for us. If these records are what the business relies upon for its business purposes, that sufficiently imbues them with trustworthiness. The USPTO, with the USPTO, as I said before, evidence will consist of testimony and the referenced exhibits, paper testimony, but that same kind of foundation has to be laid in order for their records to be admissible. And that's just admissibility. Now, what about admissibility of electronic records? Well, if you read the interference cases over the last 2-3 decades, you will see that machine-generated reports and data have in fact been admitted as evidence and relied upon to prove dates of invention, including before the board. These are all examples that I took out of cases, individual cases. That represents just 6 individual cases where this was the evidence that was relied on, and it's all electronically generated evidence. Nuclear magnetic resonance and infrared spectroscopy, chromatography, elemental analysis, differential scanning, calorimetry, gel permeation chromatography, thermogravimetric analysis, and there's a case from early in the 2000s, I believe 2003. It's a Federal Circuit case where the discussion is actually of use of email to prove invention dates. Electronic records, of course, not even what we would think necessarily about as part of an electronic lab notebook. But again, at the time those inventors or whoever sent the email sent it, they may not have appreciated that this was going to be the critical date of invention evidence, but it turned out to be the critical date of invention evidence. And so, my point is that I think it's dangerous to think about focusing on something, perhaps a product that is bought off the shelf from a computer vendor, or even something that is put together in-house as being the electronic lab notebook. The attorney who comes in to help the organization prove a date of invention is going to be looking for any and all relevant, admissible, credible, and corroborated evidence. And that may or may not, it may be in electronic form, and it may or may not be inside what the organization is thinking of as its electronic lab notebook. Okay, we'll come back to credibility in a moment. I skipped over it because I think it's perhaps the most significant hurdle, or certainly one that we want to focus on in thinking about what an electronic lab notebook system would include. This requirement for corroboration, it applies, as I said, to all proof of inventive activity, including this manifestation to a third party of conception, to the actual reduction of practice, and to diligence. And the board has told us in several cases that the issue of corroboration is an issue distinct and separate from that of admissibility. So it is one thing to get your records into evidence, but you have to think about where is the evidence that emanates from the non-inventors going to come from that is going to corroborate every aspect of what I need to prove. Every aspect of the conception, every aspect of the reduction of practice, every day that I need to prove that I was diligent. Now, how about that rule of reason I alluded to earlier? Well, over-the-shoulder observation is still strong evidence. Of course, if you have a witness who actually saw the reduction of practice take place, and that witness can come in and credibly testify to that, think about it. You wouldn't even need paper evidence. You have the inventor's testimony, you have the over-the-shoulder witness testimony, so it's possible, in other words, to prove an invention date without any records, any documentary evidence. And I'm emphasizing this just to encourage us to think expansively about what constitutes evidence of invention. So certainly that kind of over-the-shoulder observation by a non-inventor will be strong evidence. Under the rule of reason, circumstantial evidence can suffice. And the rule of reason goes as follows. There is no final single formula that must be followed in proving corroboration. So there is, again, no magic bullet. The board is not going to tell us exactly how to construct our record-keeping or evidentiary systems inside our research organizations. What we are told is that all the relevant evidence must be considered, or is to be considered, in order that what? That a sound determination of the credibility of the inventor's story can be reached. This softening of the requirement for corroboration is based on what the board has said is a recognition of the realities of technical operations in modern-day labs. And the recognition that the over-the-shoulder requirement, quote, plainly does not comport with the reality of technical operations involving numerous people necessarily separated from each other in time and distance, and each involved in their highly specialized part of a large operation. So it's practicalities, it's pragmatic. Some examples, just briefly, a Federal Circuit case in 1985. I think these are very helpful, illustrative facts. The invention was a process for copying video discs. This was actually a Kodak case. The party Thomas came in with Thomas's affidavit and notebook entries, fine, but that evidence has to be corroborated. It emanates solely from the inventor. What else do they have? They have the testimony of 2 non-inventor witnesses and additional documents. And look at the additional documents, because I think this is so helpful. They had one research associate's testimony that he had supplied the starting materials to Thomas prior to the reduction to practice event that Thomas was relying on. You have Thomas's requisition forms, the forms through which he requested those starting materials. Those bore pre-asserted reduction to practice dates. And then you had another research associate's testimony that he examined the product of the process prior to the asserted invention date, or the legal invention date. So the point is, you had bookend testimony. You had the testimony of a non-inventor who said, I gave Thomas the starting materials. You have the testimony of another non-inventor who says, I saw the product. bookends. Here's another example. The invention was a antibacterial cephalosporin, and the CCPA, the Court of Customs and Patent Appeals, which was a Federal Circuit's predecessor, characterized the party Burgess's evidence as a cohesive web of evidence, including, and the list actually runs on for longer than this, but I just chose some of the things: testimony of a non-inventor analytical chemist regarding her supervision of elemental analyses of the sample that is asserted to represent the reduction of practice, testimony of a sample custodian, testimony of a lab director that under his direction and according to routine, beautiful words to come out of a witness's mouth, samples received from Mr. Burgess were assigned a particular designation, testimony of an immediate supervisee regarding his synthesis of starting materials, testimony of microbiologists regarding in vitro and in vivo testing of the produced product. All these people are non-inventors. They're all around to testify about what they saw, handled, and witnessed as of the time of the event. So this is this notion of the cohesive web of corroboration. Okay, so what about credibility? Well, the ultimate problem there, of course, is how are we going to imbue electronic records with this reliability of the traditional paper records? So in thinking about that, again, for reasons I think that make sense, it's advisable to think about the analog world. How does the paper record system operate? What attributes ought electronic notebooks systems have? First and foremost, the author's signature. Now, I say it's neither necessary nor sufficient. I say that because, again, theoretically, it's possible to prove invention dates without any documentary records if you have perfectly complete, credible testimony. And interferences have, in fact, been won without reliance on any documents. So I say that again to emphasize that I think it's inadvisable to fixate and to invest too much hope in what our documents and records can do for us without looking at this the way that a lawyer will look at it when they go to prove date of invention. So it's neither necessary and it certainly won't be sufficient. For one thing, the author's laboratory notebook signed by him is a matter of law insufficient to prove a date of invention. Well, so why do we bother then? Well, we bother for lots of reasons that litigators appreciate. For example, the signature connects the entries in a given paper or electronic lab notebook system with the authors, and they help the litigation attorney make the case. They can give us information about who can authenticate, who can be the foundation witness for this record's admissibility. And is he or she an inventor? Is it corroborative evidence, or is it evidence that must be corroborative? So that function alone makes it entirely worthwhile. There are technologies out there that allow us to do this in different ways, and think of them as something you know, something you have, something you are is just some examples. Something you know would be a password. Something you have might be some sort of device you carry around with you that you sync up with the computer. Something you are would be biometric identification, like a retinal scan or a thumbprint or something like that. The point is that you need something that is reliable and credible in order to connect the record with the record maker and the record keeper. What's most important is that you're prompt, right? An inventor a record that is created but not promptly committed to a secure storage device will not be useful to prove a date of invention up until that date. So the point is to be prompt in doing that kind of connection. Something else that traditional lab notebook systems have that we should think about in the electronic lab notebook world are dates, of course. I mean, obviously, an undated record when it comes to proving a date of invention is about as worthless as it can be. So there has to be some sort of dating, and in the electronic system, electronic realm, what we're talking about is some sort of accurate and ideally, and this is, of course, an advantage that the digital world offers that the paper world does not, some sort of automatic date stamping system. The record is dated as of the moment of its creation without any kind of human involvement, and therefore limiting the possibility of delay and raising questions about credibility. Such a thing might take the form of some sort of internal organization document management system. Again, you certainly would want it to have the document management system to be something at a minimum that the inventors do not have control over, right? You're going to need a non-inventor witness who's going to be able to come in and talk about the structure and operation of the document management system. Some organizations go further. They use some sort of third party, so-called digital notary or surety service, to whom records are transmitted and automatically date stamped, and therefore they're in the control of the third party, which has obvious advantages in terms of imbuing them with credibility. What else do you need in an electronic lab notebook system? Well, you need protection against alteration. Think about all of those attributes that I walked through when I was talking about paper notebooks and the way researchers are taught to keep paper notebook records. This protection against alteration, or at least the ability to detect when alterations have occurred, is in fact the basis for many of those paper notebook keeping procedures that I walked through. And again, there are technologies out there to do this: digital signature, digital notary, or some sort of audit trail technology. You can have a digital signature that will assure us that the record has not been altered, or a digital notary that will do the same, or at least at a minimum an audit trail so that we can see who accessed the record and when and how it was altered. What about witnessing? Well, again, witnessing is neither necessary. There have been interferences, dates of invention proved based on oral testimony alone, and using unwitnessed records. And it's not necessarily sufficient for reasons that are complicated, but the mere fact that a notebook entry is witnessed, is signed by a witness, even a non-inventor witness, will not necessarily prove anything. Perhaps if that witness is unavailable to testify, to authenticate that that's his or her signature, and there is no other way to authenticate that witness's signature, it will be disregarded as a matter of evidentiary practice. And so what happens is, of course, every case is established on its own facts and taking a look at the evidence as a whole. So why witness? Well, there are tremendous benefits to having records witnessed. And there are electronic lab notebook products on the market that will do this, a record is generated, a witness receives an email, the witness then knows to go in and sign the record. The witness's signature will, at a minimum, corroborate that the record existed as of the witnessing date, assuming that there have been non-alteration safeguards put in place, and assuming that the witnessing has been done promptly. And this can be sufficient in itself to establish and corroborate, for example, conception. Actual reduction to practice might be a different situation. But again, witnessing notebooks has a tremendous practical benefit, because for the lawyers who come in to prove the date of invention, it tells us who was around, who might have knowledge, who might be a good oral witness, a testimonial witness. And so there is a tremendous practical benefit entirely aside from having the signature on the document. Finally, an electronic lab notebook there must be a recognition that, again, the notebook will not function and manage itself. Any system, whether it's a paper notebook system or an electronic laboratory notebook system, the people who are using it have to be trained, and there have to be policies set up around the use of the requirements. Just like when I went into work in the lab, and on the first day I was issued my lab notebook and taught how to use it, there have to be established policies and procedures for using storage and migrating records in a digital environment. And it is important, I think, to emphasize that the more routine and the more user-friendly these policies and procedures can be, the more likely they are to be followed, and therefore the more likely they are to be able to be relied upon to establish credibility. There has been an increase in the use of electronic laboratory notebook technology. In the past several years, it's been a slow process. I mean, as I said, I was working on this in the early 90s, and there still is some hesitation and reluctance, as evidenced by this quote from this May 2007 Scientific Computing article. Over 70% of companies who have implemented an electronic lab notebook still create paper printouts and apply wet signatures of the author and witness in what is known as the hybrid model. There are additional resources available. The Collaborative Electronic Notebook Systems Association has an excellent website, tons of information, some of it for sale, about constructing electronic lab notebook systems. And several years ago, the FDA actually adopted regulations. Of course, these are not relevant to patenting and proving dates of invention, but they set forth detailed regulations that provide criteria for electronic record keeping that the FDA will accept in certain circumstances. And so for someone brand new to this subject that wants a complete list of at least what one federal agency regards as the kinds of attributes and ingredients that the system must have, that's a helpful resource. Closing thoughts, lab notebooks, whether they be paper or electronic, are just one aspect of a larger system, and I hope that I've been able to make a persuasive case for that today. There have to be policies and procedures. They have to be regularly used, routinely used. They have to be workable or they will not be used. And people are critical for all of the reasons that I've talked about. People have to be well trained, and you're going to need people to get records into evidence in our system. In other words, documents regarding an inventive activity, quoting from the CCPA here, they don't ordinarily speak for themselves. The board, in fact, has a specific rule that the significance of documentary and other exhibits identified by a witness in an affidavit or during oral deposition shall be discussed with particularity by a witness. There are board cases where parties submitted lab notebook evidence and didn't explain the significance of what the documentary evidence showed. There has to be people, knowledgeable witnesses who can explain documents to the board. The board will not take them for themselves. My bottom line, in closing, invention dates don't prove themselves, whether the notebook is paper or electronic. The attorneys will be worrying about the legal definitions that we've talked about, how the proof that is being looked at aligns years after the fact with the actual subject matter that is at issue in the interference, whether there is this kind of cohesive web of corroboration, and who are the people who can authenticate and testify. And with that, I'm happy to take questions.
One thing I was wondering about is what happens when your IT administrators leave, from 4 or 5 years ago. Have you read whether the administrative policies about how those records are kept and maintained, can they be put into evidence by the new administrator, or are there other things that companies should do in anticipation of their IT administrators leaving?
Well, and this is, of course, a bigger problem for smaller organizations than for large organizations, because in a large organization, the fact that the manager left doesn't necessarily, it's not only the manager who might be able to testify, right? In fact, sometimes the manager might not be the best witness. The person who actually handled the documents, the records, might be the best witness. I have not read a case involving that specific situation, but my sense of the law in that regard is that the business records exception is forgiving enough to accommodate that kind of change. You could have a witness who could come in and testify as to what the procedures of the organization have been for many years, even though he or she wasn't the person actually doing the keeping of the records. And presumably that's enhanced by the documentary evidence that the IT people are keeping with respect to their policies and procedures for keeping records.
Perhaps we should just mention that if there are other questions, they can email them in.
Yes, if anyone has any questions, please email them.
To NYS.
And to NYS
STLC at law.
at law.syr.edu.